Hi there, and welcome to the Music Law session presented by Long McQuade as part of the Livestream series. My name is Byron Pascoe. I'm a music lawyer with the law firm Edwards Creative Law. While this session is being pre-recorded, I will be there live during the live stream to answer your questions and comments. A quick legal disclaimer. This presentation is for information purposes only and is not to be considered as legal advice. If you have a question with respect to your specific circumstances, please contact a lawyer. A little bit about me. My background is in theater. Then I went to business school, ran a television and new media production company for 5 years, then went to law school, worked as a corporate lawyer for a few moments, and then I've been practicing entertainment law ever since for the last 6 years. I work predominantly in music and then film and TV, and I also work with other creators and creative companies. So what we're going to talk about today, initially we're going to talk about music Q&A, some of the most common questions that I get asked as a music lawyer. We're going to talk about my favorite 9 words, which are, what are your expectations of me and my music? We're going to talk about 2 of the most common music agreements, a producer agreement and a manager agreement. And then we're going to chat a bit about music agreements generally, some things to watch out for, so some red flags, and some negotiation tips with respect to music agreements broadly. First thing we'll talk about is general Q&A of music law. So one of the questions that I get asked is whether this agreement is legally enforceable, which means does it actually, will it hold up in court? Is this something that is actually, does it meet all the needs of what would constitute an actual agreement? Some people think that you have to take an agreement to a lawyer to get signed or stamped or something like that. You don't need a lawyer to have an agreement that's legally enforceable. The elements that make an agreement legally enforceable is that there is an offer, someone is offering something to somebody else, an acceptance, the other side accepts the offer, and consideration, which means that both sides get something out of it. Does it have to be fair? No, but both sides have to get something. A related question is about whether an agreement, if it's just verbal, if 2 people are just talking, if that's also legally enforceable. And the answer is yes, a verbal agreement's legally enforceable. The challenge with a verbal agreement is that, well, over time people might forget about what they agreed to. They might lie, which does happen from time to time or a lot of the time. They might lie about what they agreed to. And also when you have an agreement that's in writing, you generally organize your thoughts about a variety of elements of your arrangement. You kind of deal with a lot more things than you would have if there's just a verbal agreement. So a written agreement is definitely preferable, but a verbal agreement is also legally enforceable. Now there are some exceptions to the rule, like with everything, but generally speaking, a verbal agreement is a legally enforceable agreement. Another question: what do music lawyers actually do? So a music lawyer, generally speaking, helps their clients to understand agreements that they're asked to sign, helps them prepare agreements that they want other people to sign, helps them to negotiate those agreements, and generally helps them to understand issues relating to copyright and royalties within the music ecosystem. How do I copyright a song? One of the most common questions that I get. So if you have an idea for a song, there isn't any copyright protection in that idea that you have, no protection by you having the idea in your mind. But once you fix it in a tangible form, by way of writing it or typing out the song or recording the song, then you have triggered copyright protection. Do you need to register it with the Canadian Intellectual Property Office? No, but you can. One of the advantages of registering it with the Canadian Intellectual Property Office, or CIPO, is that there are some judicial, court advantages when you're dealing with a copyright infringement case, namely that the burden of proof is on the other party that didn't register the copyright in the song. How do I plan for success in the context of music? Well, my general answer to that is getting things in writing, and that's what we're talking about today with this session, about some of the common music law agreements that people can use. Is it too late to get it in writing? Generally, no. So long as both sides agree Doesn't matter if you're signing an agreement after you're working together. So let's give an example. So let's say that a manager is helping out an artist, and they started working together in January, and then in April, the manager and artist decided they want to enter into an agreement with each other about the rights and obligations of both parties. What they would do is they would date the agreement as of when they started working together back in the beginning of January. However, just because they're now into April or May or June doesn't mean that they can't have an agreement that deals with their entire relationship as of when it began back in January. Should my band have an agreement? Yes. Do many have a band agreement? No. What would a band agreement usually include? Well, it would include things such as how decisions are made, who has control, back to decisions, if there's a unanimous vote needed for certain things, if some things require the vote, for example, the founding member of the band, what happens if the band breaks up, in that case, who owns the band name, generally throughout the course of the band, how revenues are split up, how different royalties are dealt with, whether you're having a formal band agreement that's written by a lawyer or not, it's a good idea to have a conversation with the people that are in your band to talk about these kinds of things. What do I need to know about music publishing? So, I guess the first question is really, what are the kinds of publishers and what do they do? So, two of the more common publishing situations are a publishing administrator and a co-publisher. So an administrator is really a company that helps you to find the royalties that are out there that have been earned based on the use of your music. They aren't out there getting opportunities for you generally. They're just there to perform a very important function of helping to collect the money that you've earned. A co-publisher, on the other hand, is generally a party that would be seeking opportunities for your music. For example, by trying to get a bigger name artist to cut one of the songs that you wrote that isn't going to be used by yourself or your band. They're going to try to help you seek a placement opportunity for your music. For example, to have it be featured in a film or a TV series or an ad or a video game. They're also going to help you find co-writers or help to fund a trip to a writing camp. In those situations, generally the co-publisher is co-owning the compositions with you. Generally, it's a much longer-term relationship. Generally, the splits of royalties are shared in one form or another with your co-publisher, whereas with a publishing administrator, they're generally taking a much smaller percentage. The duration of your relationship with them is much shorter, but they're also performing a much lesser function. Still a very important function, but not the same function as a co-publisher. Until someone provides someone else their publishing rights, he or she owns his or her own publishing rights. You are your own publisher until you tell someone else that they have the role of being your publisher. When should I have something in place with my co-writers? All the time. So anytime that you're writing a song, whether it's with a producer or with another lyricist or someone who's creating a beat or anybody who's working with you together on the actual composition, it's a good idea to talk to them either while you're doing it or just beforehand or just afterwards about what you're each entitled to from the composition. And a very simple document that helps you to document this is called a split sheet. Generally, a split sheet would indicate who the writers are, perhaps who the publishers are, if there are any, and what the percentages of the composition with respect to the people who are involved. Should I sign this record label agreement? So, one of the more common agreements that I get asked to look at is a record label agreement. And the first question I say to the artist or the band is, why? What is the reason why you want to work with this company? What are you trying to get out of it? What have they offered to you? Why do you think that working with them will help to elevate your music and get it to more people? Essentially, a record label is a company that helps you to market your music and distribute your music. This day and age, you don't need a record label in order to get your music out there. However, a record label, generally speaking, has a lot more money than, you or you or you. So they have the bandwidth or the capital and the team to go out there and promote your music. In return, they're likely getting a percentage of the money that's generated from the sales and licenses of your music. Generally speaking, the agreement should list or should indicate how long the relationship is. It might be for a year, it might be for 5 years, it might be for the life of the copyright of the song. So very, very long time. It's important to figure out if it's the right fit, if this record label is the right partner to have for your project at this time. Just because there is a record label interested to work with you doesn't mean that they're the right partner for you. And we'll get into that a bit later with respect to some agreement considerations. But it's important, again, to figure out if they're the right partner. And then if they are the right partner, are the terms of the deal appropriate? The timeline, the amount of money that each party is getting, the geography. Is it a worldwide situation, or are they distributing you in Canada? Are they distributing you in North America? What are they doing for you specifically? Is what they're getting from sales of your music appropriate based on what they're doing? So those are some of the considerations of should I sign this record label deal? Should I incorporate? So very often one of the questions that I have a chat with a new client is about whether it makes sense for them to incorporate a business that will own and operate their music assets, or whether it makes sense for them not to incorporate. Generally, two of the reasons why someone might want to incorporate include that it provides more ability to plan your tax structure, which I'm not an accountant, I'm not a tax lawyer, but generally speaking, one of the considerations is a tax question. Generally speaking, when there's more money involved, there are more advantages to incorporate from a tax perspective. The second is a liability reason. It creates a layer of protection around you. It doesn't fully shield you from everything that may come after you, but it does in many circumstances provide a layer of protection around you. Also, it is a tool in order to structure your business. So if you're in a band of, let's say, 4 people and you have a partnership among the 4 of you, your business structure is a partnership among the 4 people. One of the other options is to put all of your intellectual property and other assets, digital and otherwise, from the band name to merchandise to all those all your equipment, to have all of that be owned by the corporation, and have the corporation itself be owned by the people who are currently in the band, and have an arrangement with the other people regarding what happens if they were to leave the band later on. So there are advantages and disadvantages to incorporate. The big disadvantage is that there's a high upfront cost to it. And the cost depends on whether you're incorporating federally or provincially. It depends on what province you're in. But there are other ongoing annual costs relating to having a corporation, including relating to tax and accounting. But again, there are advantages, and it really depends on your specific situation. What is MFN? So, Most Favored Nations, MFN. MFN comes up in a variety of situations in order to increase the likelihood that you're able to get something out of the opportunity. And I'll give you some examples. So let's say that you're asked to be one of the performers in a showcase of 5 performers, and you're offered $500. You have no idea what the other people are getting. I mean, unless you know, or unless you were told. But one of your potential responses is to say, I agree to $500 on a most favored nations basis with all of the other performers. And what that means is that if the venue or the promoter agrees to that, if the venue or the promoter or whoever it is pays another band or performer, let's say $700, then they're contractually obligated to pay you $700 as well. So they're giving you the same highest price as what all of the other people might get. Now, if there's a main headliner and that person is getting, let's say, $2,000 and you're getting $500, the promoter might say, well, I can give you most favored nations terms with respect to all of the performers except for the headliner. Headliners in their own category, they're getting paid more than everybody else. And that may be acceptable. It may be reasonable that you're being paid the same as the 4 other opening acts, but not the same as the headliner. Another situation is with respect to television placements. So let's say a music supervisor contacts you or your team, and they want to use a song that you recorded and wrote in a television show, and they offer you $2,000. you, again, have no idea what they're paying for the other music in the show. But you might say, well, we accept $2,000, but on a most favored nations basis with the other songs that were placed in this episode, in this season, in this series. That may or may not be acceptable. And again, similar to the headline situation, they might say, well, we can give you MFN terms with respect to the other songs that are in the background of this one episode, but clearly that doesn't include the theme song. Clearly it doesn't include this big song that we're bringing in for the big scene at the end. But at least if they agree to MFN terms on all of the other songs in the episode, then at least you know that if someone else is getting, for example, $3,000, that you're also entitled to get that other $3,000. Now, the music supervisor or whoever's handling the contracts needs to actually be truthful with you about the other party getting $3,000, because even if you have MFN terms, it doesn't mean that someone may not be truthful about what someone else is getting. But at the very least, if you insert that concept into some of your arrangements, you will at least have some additional protection to ideally get whatever someone else is getting if they're getting more than you. Should I submit to this contest? So, sometimes I get calls from usually parents asking about their teenagers or younger children entering into music contests. And they say, should I enter into this contest? And I guess the first response is, well, did you read the rules? The rules on music contests vary drastically from music contests that are a part of a local, let's say, music festival to a contest which is a television show, and everywhere in between. And generally, some of the more higher caliber events or programs have more intense requirements of the applicants. They may require that if the person wins, that he or she sign a deal to provide, to record an album with the relevant company. Or they may provide a requirement that you not be involved in any other contest for a certain number of months before or after. Some other limitations on what you can do. So, the limitations that are there, they're reasonable if they're reasonable in the circumstances. But it's important to understand and read the application guidelines. Make sure that they're in line with what you think is appropriate. Generally speaking, the opportunities that provide for more for the winner are going to be more restrictive on what you can do while you're waiting to know if you win, and they provide more rights to the company if you win. But that's the give and take, and you don't have to apply for a contest if you don't want to. But if you're applying to a music related contest, know what you're getting into and decide whether it makes sense, if it's worth the risks to do it. For some people, the same requirements for that company that you're signing up with is going to be reasonable, and for other people it won't, and that's okay. But read the rules, and if you want help reading the rules of a music contest, contact a music lawyer or someone who's had a lot of experience dealing with music contests. Here's another question that I get usually, or at least more so in kind of the hip-hop sessions that I do, and it's about remixes. And some people seem to think that if you're remixing someone else's song, that they'll feel honored and appreciate that you're using their music and playing around with it and maybe selling it or whatever else. And that may be true. Doesn't mean that you have the legal right to do it. But just getting back to the basics of it, that's what we're talking about today, the basics of these things. So if you want to remix someone else's song, you need two sets of permissions. You need permission to use the recording, and you need permission to use the composition. So if I wanted to remix a certain song, I would need to figure out, if I wanted to remix a certain recording of a certain song, I would figure out who owns the recording. It might be an independent artist, it might be a label. Then I'd want to figure out who owns the composition. I would see if there's a publisher involved. The way I would figure out who the writers and publishers are is that I would go onto the SOCAN repertory, or also look at ASCAP or BMI to their repertoires that list all the compositions in their catalog. SOCAN, BMI, CSAC, ASCAP, These are performance rights organizations. SOCAN is our PRO in Canada. In the States, they need to have more of everything, so they have a few, including ASCAP, BMI, and CSAC. You go on their websites, you search the name of a song. If it's on there, it'll list who the writers are. If there's publishers, it'll list the publishers. And you contact these people. By these people, I mean the actual publishers. You don't need to contact the writers. You contact the publishers. Unless there isn't a publisher listed, then you contact the writer. And so in a very simple situation, you may have one individual who owns her recordings and owns her compositions, owns and controls her compositions because she's an independent artist and she owns everything because she hasn't given any rights to anybody else. So in that situation, if I wanted to remix a song that an independent artist released, who owns her own recordings and who controls her own compositions, she alone would be the person that I would need to ask for permission to remix her song or to sample her song in some way. And in that situation, I would say, this is what I want to do. What do you think? She's either going to say yes or no. She might say, well, you can sample this part of my song, but you have to pay me a certain amount of money or list me as a co-writer or whatever it is you come up with. In a more, in a situation in which there are bigger players involved, it's a lot harder to get permission, and it's potentially going to cost a lot more money than it would with an independent artist. But the concern, or the concern if you don't ask for permission, is that if you sample a song or remix a song, but let's say sample, which is generally more common. If you're sampling a pretty popular song, if you don't ask for permission and don't get permission, then the people who own the recording and people who control the composition can come after you for copyright infringement. You've infringed their copyright. You've done something that only the owners of those rights can do. Are they going to sue you initially? Probably not, although anything is possible. They would probably say, well, I see your song made, let's say in an ideal situation, your song made, $100,000. They may say, well, in order to get permission, you need to pay us this large sum of money, and then we're not going to come after you. And for royalties moving forward, we're going to share them in this sort of split. That may be what happens. And usually, if you ask for permission and get permission, the deal that you get with those people is likely a lot more favorable for you compared to if you have to ask them for forgiveness later on. The other scenario with samples is that the people that own the recording or who control all or part of the composition may say to you, stop, cease and desist. We're telling you we have the rights, you don't. Stop. Take the music down from everywhere. No, we're not doing a deal. We don't like what you did with our music. We may or may not be coming after you, to pay us something, but we just don't want you using it anymore. So, if you put a lot of effort and time and money behind a new track, and it has a sample that you haven't cleared, you haven't got permission to use, it may be that you just get stopped. And the people who own the copyright in either the master or the composition or part thereof contact, if you're with, let's say, CD Baby or DistroKid or TuneCore, they contact those organizations and say, we're issuing copyright infringement notice. They may do it through the platforms from YouTube to Spotify. But the bottom line is that they may come after you in one form or another through a direct letter or message to you, or through the platforms or through the digital service providers, and get you to stop. So there's a variety of reasons why you should get permission. I recognize that it's difficult and can be expensive, but those are the rules. You either play by the rules, or you don't sample stuff, or you sample stuff and you hope for the best. But if you're planning for success with your career and you want every song that you do to be successful financially and otherwise, you don't want to be in a situation whereby your biggest song ever had this little sample in it, and at some point in future, the owner of the sample comes by and says, pay me. So there's a lot to consider with respect to samples and remixes, but at the end of the day, the key point, you need to get permission, if you want to do it legally, from the people who own the recording, so the master, and the people who control the composition. One more question I get sometimes is about, from Canadians, is about performing in the United States. And I, generally speaking, defer those questions to the people who are involved in visas, in P2 visas. There are immigration lawyers that help with this. There are consultants that help with this. Many people use the Canadian Federation of Musicians to help them get their P2 visas for the United States. Couple quick points. Expensive, takes a long time. So plan ahead. Talk to the professionals who deal with this all the time. If you want, I can connect you with the relevant people, but you can find them. You can find the Canadian Federation of Musicians online, and they're more than willing to help you with your U.S. with permission to perform in the U.S. They do not set up tours for you, but they help you to legally perform and work in the United States. One of the questions that I get asked is whether this agreement is legally enforceable, which means, will it hold up in court? Is this something that is actually, does it meet all the needs of what would constitute an actual agreement? Some people think that you have to take an agreement to a lawyer to get signed or stamped or something like that. You don't. You don't need a lawyer to have an agreement that's legally enforceable. The elements that make an agreement legally enforceable is that there is an offer, someone is offering something to somebody else, an acceptance, the other side accepts the offer, and consideration, which means that both sides get something out of it. Does it have to be fair? No, but both sides have to get something. A related question is about whether an agreement, if it's just verbal, if two people are just talking, if that's also legally enforceable. And the answer is yes, a verbal agreement's legally enforceable. The challenge with a verbal agreement is that, well, over time, people might forget about what they agreed to. They might lie, which does happen from time to time, or a lot of the time. They might lie about what they agreed to. And also, when you have an agreement that's in writing, you generally organize your thoughts about a variety of elements of your arrangement. You kind of deal with a lot more things than you would have if there's just a verbal agreement. So a written agreement is definitely preferable, but a verbal agreement is also legally enforceable. Now there are some exceptions to the rule, like with everything, but generally speaking, a verbal agreement is a legally enforceable agreement. What do music lawyers actually do? So a music lawyer, generally speaking, helps their clients to understand agreements that they're asked to sign, helps them prepare agreements that they want other people to sign, helps them to negotiate those agreements, and generally helps them to understand issues relating to copyright and royalties within the music ecosystem. When do musicians engage lawyers? Generally too late, sometimes anyway. I think it's never too early, generally, to have someone on call that you can speak to when an agreement comes up or a situation comes up whereby you might need a music lawyer. When can I blame my lawyer? Well, I tell people to blame their lawyer all the time when they want to have a bit of an awkward conversation with the people they're working with. So what you can say, for example, to the producer you're working with or the manager that you're talking to is you saw this, Long McQuade music law session where the lawyer was talking about getting things in writing with the people you're working with. Blame me. Say, I saw the session. This lawyer was suggesting we get in writing what we're doing here. Let's talk about our expectations of each other and put something in writing. So feel free to blame me in this session in order to start some awkward conversations, which hopefully aren't too awkward, with the people that you're working with. Why are people apprehensive about lawyers? Well, the number one thing is likely cost. And related to that, a lot of people, at least that I speak to, say to me they've never had a lawyer before, so really aren't quite sure what it means to have legal advice or a lawyer with respect to their situation. So people are apprehensive about it, but the way that you remove that apprehension is actually speaking to a music lawyer, myself or otherwise, talking about what their process is, talking about what their costs are, talking about what the lawyer can do to help, and the kinds of things that the lawyer shouldn't be doing, but that are more appropriate for other people that are on your team. Next topic is my favorite 9 words. What are your expectations of me and my music? This is a question that anyone, whether you're an artist or a producer, let's say manager, but mostly artist and producer, would ask among each other. You may ask a co-writer, you may ask a label that you're considering. It's really kind of a starting point to a conversation about what the expectations are. And we're going to get into producer agreements where we're getting into some of the more kind of nitty-gritty of this kind of stuff. But if you really don't know where to start a conversation when you're working with a new creative collaborator or someone new in your world who wants to help you to distribute your music further or to do anything with you, get on the same page about the expectations you have of each other. It could be awkward a bit, but it needs to be discussed. It needs to be discussed if you're working with a new co-writer who may expect to be your co-writer for life, or to have 50% of every composition you work on together. Those may not meet your expectations, so it's better to figure this out proactively as opposed to dealing with things later on once you've already created something new with somebody. So the question, what are your expectations of me and my music? Sounds pretty vague or pretty simple, but it can actually be a good starting point to a conversation that provides for greater understanding between you and the people that you're working with. Let's talk about producer agreements. So, of all the agreements that I work on for anyone in music, the producer agreement is probably one of the most common ones because a lot of people work with producers. Fewer people have managers, fewer people have labels or publishers, but a lot of people who put out music, unless they're producing the music on their own, are working with a producer, and it's important to clearly outline the relationship that you as the artist have with your producer. So here's some considerations for that arrangement. Number one, it's much more about, there is much more to discuss than how much money the artist is paying the producer. Sometimes when I speak to an artist, I say, what is the arrangement with this producer you're talking to? And they just say, well, they're charging me, X number of dollars per day or per song. And that's all they talked about. So, that's one factor to consider, but it's definitely just the starting point. But on that, let's say that you're paying a producer $2,000 to produce 4 songs for you. Okay, so when are you paying that money? Preferably you're not paying it all up front. Preferably you're paying part of it at the beginning and part of it at the end. What does paying it at the end mean? So let's say you're paying a producer $2,000. You're paying him $1,000 at the start and $1,000 when you're done. Well, from the producer's perspective, preferably he's getting paid by the artist as soon as he delivers the 4 tracks to the artist. For the artist, preferably you're paying the final $1,000 once you're happy with what you got. So if your deal is $1,000 now and $1,000 later, or whatever it is now and whatever it is later, it's really important to figure out if the final payment is going to be made once the artist accepts delivery, or once the producer delivers the first draft of the songs, or whatever it is the producer thinks that would properly trigger the payment. What this generally speaking comes down to is how much back and forth there's going to be at the end of this between the producer and the artist. The artist wants to make sure that she's happy with what she has. The producer wants to make sure that he's not having to make changes, for the next 10 months. So there needs to be some kind of happy medium that the parties agree is appropriate. But again, when you're thinking about, or when your payment schedule has money at the end, make sure you clarify what actually triggers that final payment. So in addition to the actual money that's being paid up front, another question is, what is the producer entitled to from sales and licenses of this music? They may get nothing, or they may get something. The challenge comes where people just don't talk about it. And the artist thinks, well, I paid the producer that $2,000. I no longer have to pay him anything. And the producer might be thinking, well, I got that $2,000. It's just an advance against future royalties, and I own this and that, and I'm entitled to this and that. Both sides have different expectations in many situations. And so, back to that question of what are your expectations of me and my music? Artists say to the producer, what are your expectations? What are your expectations about royalties? What are you expecting to get? And let's decide about whether I think that's appropriate to give to you based on what you're doing. So one of those discussions, or one of those points, is about writing royalties. Is the producer entitled to a percentage of the writing royalties in the song? Do they co-own the composition? Do they own 50% of the composition? Do they own 5%? What percent? Do they own any percent? In hip hop, which I do a lot of work in hip hop, The producers in a lot of hip hop situations, they create the beat, and the performer the rapper is writing the lyrics and performing the lyrics. And so in some situations, it's appropriate that the producer, the beat maker, is getting half of the writing royalties, and the lyricist, the performer, the artist, is getting the other half. Or it might not be that way. Just because someone is contributing the entire beat of a song or all of the lyrics doesn't mean that he or she has to get half of the composition. It depends what the people agree to. So if you're bringing, another situation is that you as the artist, you're bringing the melody and the lyrics to a session, and you essentially want the producer to record and perform audio engineering tasks and give their input on some things. But generally speaking, you're bringing the melody, you're bringing the sound, and you're bringing the lyrics. And in that situation, you might feel as the artist that you're entitled to 100% of the composition, and the producer's not entitled to any. And that might be reasonable, or it might not be. It depends on the situation. But the more the producer is contributing, usually the more the producer might be getting in terms of the composition. But it just depends on what you agree to. Again, what is a concern is if you don't talk about it, and then later on you have some song that's on the radio, and the producer hears it and says, "Oh yeah, where's my SOCAN royalties from this song? Where's my other publishing royalties from this song?" And they call you up and say, "Well, I never agreed to take 0% of this composition," and it can get a little ugly, and that happens. And so, figuring out what the percentage of the composition is that the producer is getting is an important thing to figure out early on in the process, or at least during the process or right after the process, and definitely to include in your producer agreement. The other thing that the producer might get, and sometimes get, and in many cases gets, is a percentage of sales of the music. So let's say that you're using a digital service provider like DistroKid, and DistroKid pays you $10,000 in sales from your music over the course of a period of time. It might be that your arrangement with your producer is that he or she's getting 10% of that. So that may be something, that's generally a pretty important term in your producer agreement of what the producer is getting, if anything, from the sales and licenses of the music. Important to figure this out from the outset. There's a variety of revenue formulas that can be used in your producer agreement. Some of them are just a percentage of what you're getting. Others relate to different formulas that a label might use. But at the end of the day, the question is, what is the producer getting from what you are earning or from what you're receiving? Now, let's say that you've agreed to your producer that you're going to pay him 20% of the sales and licenses from your master. And let's say that you also agree with your producer, or you ask your producer and they agree, that their fee is recoupable. So let's say that you paid your producer $2,000. Let's say that the producer is entitled to 20% of the sales and licenses of your master, of your recordings. And let's say your recordings earn $10,000. So you earn $10,000. You owe 20% to your producer. That's 20% of it, $10,000 is $2,000. But the $2,000 you pay to the producer is termed recoupable. What that means is that instead of paying that $2,000 in royalties to your producer, you're not paying the producer anything more. You're reimbursing yourself of the money that you paid your producer. So as an artist, preferably, if you're giving your producer a percentage of sales and licenses of the master, you want ideally to have all or a lot of the fee to be recoupable. In many situations, it ends up being that half of the fee is recoupable. But any part of the fee being recoupable is better for the artist than not. From the producer's perspective, if the producer feels that she's not being paid her full rate, she might say, well, I'm willing to accept $2,000, but I don't want any of it to be recoupable. So the concept of recoupable is another negotiation or part of the negotiation, but it's an important part because it means that the producer might not be paid any royalties, or they're at least delayed in getting paid their royalties, if any. One other form of royalties that the producer might get is from the featured artist share of Sound Exchange and MROC and Actor Racks royalties. These are neighboring rights royalties, as we call them here in Canada. Oftentimes, the producer will want to have a percentage of these royalties as well. And the question is, is what they're asking for reasonable? So, these things, there are different elements of what the producer might want. Money up front, money when they finish the work or when they deliver the work, money from sales of the music, a percentage of the composition, a percentage of the featured artist share of these royalties I just mentioned. And it's really a mix. It's a mix of those things that, in some situations, someone's just given money and nothing else. Other times they're given less money and a percentage of those other royalties. But the key is to figure out in advance what the producer is getting based on their contributions to the work and what they're getting from those different royalties. The other thing that you want to ensure is clear is that you as the artist own the master. I'll say it again. You want to make sure that your producer agreement provides that the masters that the producer is creating are owned by you, the artist. So you as the artist own the masters. You as the artist have obligations to your producer. But the producer is giving his or her ownership, his or her intellectual property is being assigned upon creation of the masters to you, the artist. So that's a very important part of the producer agreement. It's in every producer agreement that's written by a lawyer and not kind of found on the internet. Although some of those bad internet agreements probably include that too, because it's so important. But again, you want to make sure that there's clarity that you as the artist own the masters. Now, there's always exceptions to the rules. Sometimes it'll make sense that the producer owns the master for whatever reason. These are not, there's no rules specifically about how producer agreements need to be, but these are some of the considerations that generally speaking go into a producer agreement. And one more thing is about credit. Are you giving the producer the credit as, produced by Jimmy? Or whatever his or her name is. That's something that is, it doesn't cost you anything to give your producer a credit. It makes sense. It's normal. But if the producer also wants to be listed as a co-writer, that may or may not be appropriate in the circumstances. So it's something to think about. But all this to say, the producer agreement, very important agreement because it's a very common agreement that many artists have. Or agreements that they should have with the people that they're working with. And it's a lot easier to have these conversations about money and rights and credits and deliverables and when you're actually getting the deliverables. I didn't talk about that, but it's important to dictate when you're actually being given the recordings that after the producer has worked on it. These are important things to figure out proactively. It's a lot easier to pay. It's a lot easier to deal with royalties before any exist. So if you're working with a producer, have the conversation about what his or her expectations are about this project and think about it, see if you think it's reasonable, and get it in writing with the person. And if you want, hire a music lawyer to help you out, but at the very least have the conversation with your producer to ensure you're on the same page about your expectations of the music. Management agreements is the next set of agreements, or the next agreement to talk about today. Oftentimes people work with someone who may have been a personal friend of theirs or someone who's worked with other artists who wants to work with you to help you to advance your career. Great. It's amazing to have someone in your corner who has industry knowledge and connections and can do the kinds of things that you don't know how to do and do the things that you didn't know existed. Whether it's registering for certain royalties you've never heard of, or finding opportunities with other co-writers or other labels or publishers. When I get asked to look at a management agreement on behalf of an artist, I say, well, tell me about the relationship with this manager. How did you meet? What have they done for you? Why do you want to work with this person? Have you met them? Which sometimes they say no. So, doing your due diligence on your manager or potential manager is extremely important. It's essentially a marriage. You're essentially marrying your manager. And I actually deal with more divorces than marriages in that I end up spending more time and, unfortunately, people's money helping them to deal with situations where a management agreement or a management arrangement went sour. And in many situations, things wouldn't have gone so sour, or they wouldn't need a lawyer involved if they had an agreement from the beginning that outlined the rights and obligations of the manager and the artist. So let's talk about that. Let's talk about some of the elements of a management agreement. The first is, is the management services to you exclusive? Are you the only client or not? I mean, in some cases, it's reasonable that you're the only client, and in many situations, it's not reasonable. It's not reasonable that the manager has to only work for you. They are providing services to you. They may be providing services to a few artists, and that may be good for you. But it's important to know and have clarity about whether the services are being provided only to you, or whether the manager can provide services to a lot of people. Secondly, who are you actually contracting with? Are you contracting with a manager individually? Joanna, is Joanna your manager, or is it Joanna Management Incorporated? If it's Joanna Management Incorporated that you're entering into an agreement with, what happens if Joanna, who you work with, leaves the next day, and you have a long-term agreement potentially with this company, but the company is no longer owned and operated by the person that that brought you into the company, that you expected would be providing services to you. So there are ways to deal with that situation. One of them is with a key person clause, in order that provides you as the artist the ability to exit early, or to have some other protections if a certain person should leave the situation or is no longer involved on a day-to-day basis with you. Another key question is how long? What is the duration of your management agreement? Is your management agreement 6 months, a year, 5 years? 5 years sounds a bit unreasonable. 6 months sounds great, but a manager is going to want to have a longer-term commitment than 6 months. An artist may want to have a shorter commitment than 5 years. So it's about finding the amount of time that is appropriate for you as the artist, and you as the manager. There's no easy answer of what is the appropriate amount of time. It's the amount of time that makes sense for both parties in the circumstances. What is the commission, or what is the manager getting for doing the things that they're doing? In many situations, it's a percentage of the revenue that the artist makes. There might be some exclusions on that revenue. So, for example, if I teach guitar lessons, and that ends up being how I spend a third of my time, or 25% of my time, and I was doing this for a while before this manager was helping me out, it probably doesn't make sense that the manager get a percentage of commission of my music teaching sales. So oftentimes when I work with artists and helping them with the management agreement, I say, well, what are the music things you're doing, or what are the entertainment things that you're doing that really shouldn't be connected to the commission that the manager is getting? And so those things should be excluded from the scope of the commission that the manager is getting. What percentage makes sense? Well, whether it's 5, 10, 15, 20, again, there's no magic number of what percentage a manager should get. It might be 50%, it might be 1%, probably not 1. But it really depends on the circumstances. Is this manager, your buddy who doesn't really know too much about music, or is this a big name manager in the industry who has a lot of connections? You're going to end up paying that manager more than you would to someone without those attributes and skills, because they're bringing a lot more to the table, and they're going to command a higher percentage of commission. Some managers decide that it's appropriate that they only commission off of touring. Some managers think it's appropriate not to commission off of writing royalties. It really depends on the circumstances. But generally speaking, one of the ways that artists compensate their managers is by providing a percentage of the royalties and other music and or entertainment revenue that the artist earns. When do they pay them? It might be on a monthly basis. It might be on a quarterly basis. It might be that all the money flows through the manager, and then the manager pays the artist every 2 weeks or every month or something. It really depends, again, on the circumstances. But these are the things you're talking about. How is cash coming through? How is it being paid to the artist and manager? What percentage is the manager getting? Those are some of the relevant considerations. If you're an artist, you want the manager to be responsible to do, A, B, C, D, E, all these different tasks. And if the manager doesn't do those things, you may want to have the right to leave that arrangement. From the manager's perspective, you want to have the authority to do all of these things, but not so much the obligations to do these things. So from a manager's perspective, how she wants an agreement to be is that she has the authority to enter into agreements on behalf of the artist, that she has the sole authority to book the artist for gigs, but not the requirement, so that if the art manager doesn't end up doing a lot of these things, the manager isn't offside with his or her agreement. So it's important to figure out, whether you're the artist or the manager entering into a management agreement, do the tasks and the services, are they required of you, or are you given the authority, or someone given the authority to do them? And that's where some of the power balance lies. If for you as the artist, if I'm representing the artist, I want to have some requirements that the manager is going to do. If I'm representing a manager in a situation, and I represent both artists and managers, if I'm representing a manager in a situation with an artist management agreement, I preferably want the agreement to say that the manager can do, has the authority to do everything, but not the obligation to do anything. So it's important to read the agreement that you're offered, or to talk to your lawyer about what you want the agreement to say. But there's that there's a balance. You need to figure out the balance of what the requirements are of your manager and what the entitlements are of your manager. One other thing about management agreements is what's referred to as a sunset clause. So the concept here is that a manager arguably or reasonably is entitled to continue to earn revenue after he or she is no longer providing management services to the artist. That concept, I think, is reasonable so long as it's reasonable, meaning that preferably if a manager works hard for, whether it's 3 years or 3 months, but if they accomplish a lot in the time that they're managing the artist, if the artist says, now I got big, I don't need this manager anymore, have a nice day, it's appropriate for the manager to be continuing to earn something from the hard work that went into managing the artist. What percentage should they be getting? How long should they be getting it? There are 101 different formulas for what would be appropriate, but it's something to think about and to talk about with the other party and to get advice from your lawyer about. But again, I do think sunset clauses are reasonable so long as they're reasonable. Let's talk about music agreement tips and red flags. So the first tip is you don't need to sign the agreement. What I mean by that, if you get offered an agreement, whether it's a label or a publisher or a manager or whoever, someone wants to do business with you, that's very nice. You don't have to say yes. It's very nice to feel wanted. We all want to feel wanted. We all want to feel like, we've got this, some record label halfway across the world wants to release our music in wherever. That's nice. Doesn't mean you have to do it. It's not just about the money. Any kind of agreement that you get, some of them will have some kind of money attached, either as money up front or as a percentage of royalties. This is common for, let's say, a record label agreement or a publishing agreement. Money isn't the only thing in life and otherwise, but in your agreement as well. If you're with a record label, or a record label rather wants to sign you and they're offering you some kind of monetary advance that sounds great, that's not the only factor. That's not the only term of the agreement. If you want the let's say the label to do something specific, for example, you want them to press 1,000 vinyl copies of your next album, that's something that isn't specifically money to you. It's something that you want them to do. What do you want the other party to do? What do you want them to give you? What do you want them to do? It's not just about money that they're offering you, it's what else you want. So figure out what else you want out of a music agreement relationship, or a relationship that's being documented in an agreement. And again, it's money is one thing, but it's not the only thing. Lack of clarity is a problem in a lot of agreements. Some agreements that I read, especially ones that were taken off the internet somewhere, aren't clear. They aren't clear about what exactly the situation is between the parties. And the reason to have an agreement is to outline the rights and obligations of the parties that are involved, the people that are involved, or the companies that are involved. So if you read an agreement and it's not entirely clear of what's going on, ask for clarity. Ask the people who gave you the agreement to indicate with more clarity about what your arrangement is. It's not unreasonable. It's nothing you ask, or at least in this situation, nothing you're asking is unreasonable if you're asking for an agreement to be more clear about what the actual arrangement is between you and the other people that are involved in this agreement. Another red flag in music agreements is not having provisions in the agreement to get details about the sales of your music. So some music agreements may list or have some sort of formula whereby you're being given a percentage of profit or some other formula, but it doesn't actually say that you're entitled to get the data that backs it up. So you want to make sure in a music agreement, if you're being paid by the other party, that it's very clear when you're being paid, what reports you're being given, what your audit rights are relating to getting more information. But you want to know where the information comes from. Oftentimes in music and also in other areas of arts and entertainment, I'm told by my clients that they got this report and it's useless. It has no information, or it's in some kind of weird format that they cannot possibly understand. So what you want to do proactively is in your agreement, clarify what information and when you're getting, which is being used to determine how much money you're being paid. So what have we talked about today? We've talked about some of the major questions and answers that come up in music law agreements. We've talked about your new favorite 9 words. What are your expectations of me and my music? We've talked about producer agreements. We've talked about management agreements. We've talked about some of the key considerations, some of the red flags of music agreements generally. And we've really just scratched the surface. Every agreement has a variety of elements to it. There's a variety of reasons why it may make sense to work with somebody else, and why it may not make sense to work with somebody else. The key aspect, as I've talked about, is you want to make sure you're working with the right people. And that really comes first, and all this other stuff comes afterwards. But finding the right partners will help to reduce the likelihood of drama and of conflict. And working with talented people can help you get to the next level. And some of these agreements can help to define your relationships, but really it starts with working with the right people. So I wish you all the success with your musical careers. If you have any questions or concerns about these agreements, or if you need help with anything else, please contact a music lawyer, including myself, and we'd be happy to have a conversation and see how we can help. I would like to thank Long McQuade for this opportunity to speak to you today. I'd also like to thank SGM Group Artists Studio in Ottawa, where I'm speaking from today. I'd like to thank you for spending your time with me to talk about something that some people think is dry, but it's exciting to me at least, music law agreements, and I look forward to connecting with you in future. I'll leave some links to find out some more information, some more blogs and things that I've done. And again, best of success with your careers. Music is a business, so definitely keep that in mind with everything you do. Plan for success. Every song you write, you have no idea which is the one that's going to be the big money maker for you. So plan for success, find the right people. Music is a business. Good luck. Take care.